Okay. O'Connor versus Donaldson, 1975, a Burger Court decision. Um, you cannot keep somebody institutionalized against their will unless they pose a clear and present danger to themselves or to others. O'Connor versus Donaldson reverses decades of social policy that allowed people to be committed to insane asylums, often against their will, by either their families or by public institutions like the police or by local psychiatric hospitals or whatever. The decision in the previous, before this case, was that the good of society outweighed the rights of the individual. But one of the basic shifts of the Warren and Burger Court era is the shift away from things like that towards an absolute defense of the civil rights of the individual as broadly interpreted as possible. So, only if it can be proven that a person demonstrates or poses a significant danger to themselves or others can somebody be institutionalized against their will. Otherwise, if they want to get out, you got to let them go. And from this, by the way, comes the right to refuse medication, the right to refuse treatment, and a bunch of other things that have since been clarified by our courts. In 1978, you have the Regents of the University of California at Berkeley versus Bakke. And this decision is about discrimination, particularly the discrimination of affirmative action. The Civil Rights Act of 1964 said that race shall not be used as the basis of decision making by the government or by large businesses when it comes to hiring, or by real estate developers in terms of selling property, or by colleges in terms of admission. But after that nullifying of racial preferences and leveling of the legal playing field, many people who were progressive said, but we have institutional racism that goes back hundreds of years and is deeply ingrained in our society. And the only way that you're going to compensate for that tendency to have privilege for white people is to reverse discriminate, to engage in racial hiring preferences and selection preferences that favor minority groups and previously disenfranchised groups. This is called affirmative action. And Bakke was a candidate to enter the University of California at Berkeley. And for 3 years, he tried to get in and couldn't. And he finally sued them because, again and again, significant percentages of people who were accepted scored lower than he did on the standardized tests necessary for admission. He was arguing that he was being unlawfully discriminated against because of his race, and that was just as evil as any other form of racism. The Supreme Court under Berger splits the decision and says that Bakke should be admitted, but that affirmative action, which are racial preferences for previously discriminated groups against groups, is admissible and possible and legal within limits in order to correct past wrongs and create a more level playing field. Since then, there have been several decisions that make that sort of broad statement a bit more restricted. Now we shift ahead from the 1970s up through the Lawrence versus Texas decision of 2003, which is a late Rehnquist court decision. I'm not saying that no important decisions happened in the 80s or 90s. That's obviously not true. But I'm focusing on particular things, and I only want you to have to identify on the upcoming tests a limited number of court cases. So I've had to make some decisions. In Lawrence v. Texas 2003, I am going to say that it has to do with ending anti-sodomy laws or anti-homosexual laws at the state level. Basically, police ended up having to go into a home. Two guys were caught in flagrante delicto with one another, and they were arrested on the basis of Texas's anti-sodomy law, which is the practice of sexual homosexuality between men. This is 2003. It's barely 17 years ago. And only then does the Supreme Court come down against anti-homosexuality laws. So this should give you an idea of how recent the whole LGBTQ rights movement has been in terms of successfully changing standards and changing law. It's really within the last 20 years. The District of Columbia versus Heller is the first of our Roberts Court era decisions. And this is a huge one. For the first time in 70 years, in 2010, the Supreme Court, so what year was it the last time they did a Second Amendment choice? For the first time in 70 years, in 2010, the Roberts Court takes a Second Amendment case. So it was 1940 the last time a Second Amendment case had been taken. A guy who worked in D.C., Washington, D.C., who was armed as part of his job, had a gun as part of his job, was arrested because he had a gun in his home. And he appealed all the way up to the Supreme Court, saying that the anti-gun laws of Washington, D.C. were a violation of his Second Amendment rights. The court agreed and made explicit something which earlier courts had sort of fumbled on, and which the anti-gun movement has often said. The wording of the Second Amendment is that well-regulated militia being necessary for safety of the public, I forgot that phrase, but it basically means this is safety of the public, a person's right to keep and bear arms shall not be infringed. Arms are weapons, guns, firearms. So, a lot of people before Heller had argued that the Second Amendment was a right only if you were a part of an organized and well-regulated militia, which is basically like a volunteer fire department of soldiers in case your area gets raided by Frenchmen or Indians or frontier bandits or whatever. But in fact, many people on the conservative side have argued that it is absolutely an individual right and it should not be infringed. Well, since Heller, local jurisdictions that try to restrict the buying and selling and possession of firearms have it much more difficult, because the Supreme Court has made it very clear in Heller that the right to keep and bear arms is an individual right. You do not have to be a part of a militia, and that shall not be infringed. National Federation of Interstate Businesses versus Sibelius, also 2010. This one is the equivalent of, what was it here? The Heart of Atlanta Motel versus U.S. 1964. The Civil Rights Act had passed in 64, and Heart of Atlanta Motel was arguing that it was an illegitimate law. The Obamacare national health care system was being set up in 2010, and there were arguments that it was unconstitutional, which I personally believe, right or wrong. In this case, the U.S. Supreme Court under John Roberts, and Roberts was the swing vote here, decided not to call it unconstitutional. Even though the federal attorneys who argued for Obamacare said in the case of another aspect of the law that it was not a tax, it was a regulation, it was definitely not a tax. Chief Justice Roberts, in order to allow the law to be the law of the land, said it's a tax, and the federal government's right to tax individuals shall not be questioned in this case. So through a contortion of the law, Roberts, in a 5-4 decision, permits Obamacare to go further. And we now have federal government health care, at least to some degree, as a result of that decision. Like the Heart of Atlanta Motel decision, it reinforced a legislative initiative, in this case, Obamacare in 64, the Civil Rights Act of. Citizens United versus the Federal Election Commission, also 2010. This one had almost a dust-up between the President of the United States and Justice Alito, Samuel Alito, during Obama's State of the Union message, I think in 2011, because Obama criticized the Supreme Court's decision in Citizens United, and Alito silently but visibly mouthed, which is a breach of precedent. First of all, the president should not be attacking the Supreme Court when they're a captive audience and their decisions, and the Supreme Court traditionally stands stock still like stone statues. There's a lot of ST words there, and Alito didn't, so both sides ended up looking bad. Citizens United sees corporations as individuals and sees political campaign contributions as an aspect of free speech, which is something that Republicans liked and Democrats did not. Obergefell versus Hodges, 2015, is the decision that allows for homosexual marriage to become a nationwide phenomenon, because to have some states restrict it would be a violation of their constitutional rights, so the court says. Finally, in Carpenter versus the U.S., 2018, you have a decision that says that a person's digital trail, their cell phone records, for example, are private, and that the government needs to acquire a search warrant, or that the standards that govern probable cause and reasonable suspicion in other types of evidence also apply here. That where possible, a person's data is private, and the government shall not intrude upon that without probable cause and probably a search warrant. And many more. These are just a few cases, 28 of them, that scratch the surface of the U.S. Supreme Court and its affecting of the Federal Republic. So this week we've gone over a quick and dirty history of the Supreme Court and many of its court cases. You will have a test on this unit that deals with that. With last week's talks on the judiciary in general, and with this week's details on the history and on certain court decisions. So be ready for a test coming up that you are going to take before the end of the year. Thank you for your attention this week. Have a good day. Miss you.